Hey, everybody. Welcome to a surprise live. Good to see everybody. Welcome to everybody joining me in the light of day. How about that? For those of you who are following from other places, um, you might catch a live. So, welcome. I want to talk just about the issue of Chad Daybell's attorney, John Pryor, filing a motion to withdraw from the case. I am sure by now you have seen enough of this to know that that's what Pryor is doing. I'm going to try and deal with a split screen because I really want to read a few of these documents. So bear with me if it appears that I am looking off camera because I'm dealing with two screens. So, but I do want to read through John Pryor's declaration. So I'm trying to pull it up. The county website, the way that they scan their documents is a little problematic at times because their documents don't always scan properly. And sometimes what happens is we end up with partial documents, which is what I'm dealing with here. So let me just keep working on that while we're chatting because impromptu live, right? So let me just see if I can get this document pulled up in a way that will actually allow me to read it. So, Declaration of Counsel. So, for those of you who are unaware, gosh, it's just endlessly loading the second page. There is going to be a hearing. Originally, John Pryor noticed this hearing because in Idaho, that's the way it works. When an attorney asks the court for a hearing, they contact the court clerk, set up a hearing date, and then notice everybody on it. However, in this case, the judge decided that he wanted to hold a hearing earlier. So John Pryor originally noticed this hearing for, hang on, I'm adjusting my camera here. Noticed this hearing for the 30th of January, and Judge Boyce has now moved that up till the 18th. So next week, there'll be a hearing on this, 10 a.m. It will be live streamed as usual. So let me, of course, this darn thing is just loading. So I'm going to let it load for a minute. I'll start with the motion to withdraw. Sorry. And I'm just going to look away at my other screen. I'm having trouble getting it to display on the screen at the same time, but I will keep trying. So John Pryor says, the undersigned counsel hereby moves to withdraw his counsel from this case. Since May 25th, 2021, the undersigned has represented Mr. Daybell in this case and the related previous case, which was the original case that they were arrested on. The original case was the charges of destroying or concealing evidence. Those were the original charges. Remember, they were charged under those charges, and then it was another year because of COVID before the murder charges were actually presented to the grand jury, and the grand jury issued an indictment. So John Pryor's actually been on the case since the children's bodies were found in June of 2020. In the time in that time, the undersigned counsel has undertaken as sole counsel all matters of representation, including obtaining and reviewing discovery, conducting investigation, and hiring and working with numerous experts. So I do not remember this happening, although it may have happened in one of the numerous closed hearings. But at a hearing on January 19th of 2023, so almost exactly a year ago, this court inquired of Mr. Daybell and declared him indigent. Mr. Daybell does not have the ability to pay for counsel's continued services, and Mr. Daybell seeks the appointment of 2 qualified capital attorneys. As this court is aware, this case is both extraordinarily complex and hang on here. I don't know why, but the Idaho courts sometimes will scan one page of a document one size and another page another size, so suddenly we get this big blown up document. Or they might actually skip pages, which is super frustrating. So as this court is aware, this case is extraordinarily complex, and the state is seeking the death penalty, which requires counsel to essentially prepare for defendants. I am having a terrible time because this document is blown up. So, which requires counsel to essentially prepare for 2 trials, because there's a guilt and innocence phase and then a mitigation phase. Then it says, C, motion to continue the trial date to enforce Mr. Daybell's constitutional rights. That was more than a year ago. Reflecting this complexity and the work required to prepare to try the case, this court has set aside 2 full months for a trial. And the prosecution team consists of no less than 5 attorneys, including an out-of-state attorney hired at taxpayer expense. That's Rachel Smith. Remaining on this case would require the undersigned counsel to work around the clock more than full time for more than 4 months without compensation and without the assistance of any other counsel. What he says is, I have made a diligent effort to find a lawyer to assist in this matter for a significant amount of time. The attorney who I located and who agreed to get qualified has not yet been approved by the Public Defense Commission. The time for him to be of any assistance to me in preparing for this trial is long gone. Because Mr. Daybell is facing the death penalty and has been determined indigent, he's statutorily entitled to the appointment of 2 counsel who are capital qualified. The Idaho State Public Defense Commission maintains a roster of capital qualified attorneys. While the undersigned counsel would accept appointment to this case if it were non-capital, because Mr. Daybell is facing the death penalty, undersigned counsel cannot be appointed pursuant to statute. The counsel therefore moves to withdraw. And he also notes in the affidavit, which is still trying to load, that Mr. Daybell concurs with his motion. I don't know why. He says, I've acted as sole counsel on all aspects of representing Mr. Daybell in this case and have fully expended the retainer of this case in providing representation to Mr. Daybell. Then the second page of this declaration just keeps saying it's loading. So I apologize for that. I don't necessarily have any control over the way the state's website works. So unfortunately, we're not able to see. I pulled it up last night and read it, but right now I'm not able to access it and read it to you. odd, but so let's talk about, in general, attorney's obligations to represent a client. So when an attorney is retained, they are required to expend and use their best efforts and to zealously represent their client. But there is nothing within the ethical guidelines that requires an attorney to work without pay. Here is the sticky point. It's also required, both ethically and by statute, that an attorney cannot withdraw if their withdrawal would impact negatively on their client's right to a fair trial. So there is this balancing that needs to happen when the court is allowing or considering whether or not to allow an attorney to withdraw from a case. In civil cases, it's less complicated because there aren't as many constitutional guarantees. There aren't as many constitutional guarantees for a civil client as there are for a defendant in a criminal case. So, because a criminal defendant has a heightened right to due process and a heightened right to constitutional protections, it means that the court has to weigh whether or not the attorney withdrawing will in any way compromise the defendant's right to a fair trial. The court also has to consider whether requiring the lawyer to stay on and go forward will also impact whether or not the client can get a fair trial. So Judge Boyce has to ask, if I were to require John Pryor to continue on this case, would it compromise Mr. Daybell's right to a fair trial? If I allow him to withdraw at this late date, which one will work against Chad Daybell worse? I mean, the judge has really got to balance those issues. So the judge is going to be looking at, first of all, this is a death penalty case. And as we've heard 100 times from a Supreme Court case, death is different. So when you're dealing with a death penalty case, you have to decide this differently than if you were looking at a death penalty or a non-death penalty case. The judge has to ask whether or not Chad Daybell's rights to a fair trial are going to be compromised by his allowing his lawyer to withdraw. Or will they be compromised by requiring his lawyer to go forward to trial? So John Pryor is making has put the judge in a difficult place because John Pryor is making a pretty compelling argument that John Pryor's rights are going to be compromised if in fact he's required to stay on the case. Now, what do we compare that to? We compare that to if he's allowed to have two court-appointed attorneys. So the judge is having to say, if I force Chad Daybell to go to trial in April using John Pryor as lawyer, is Chad Daybell's right to a fair trial going to be compromised? This is not an issue of whether or not it's going to be a hardship for John Pryor to continue on the case if he's required to without payment. Okay, that's not the issue. I realize that everybody wants to say, well, John Pryor should have known better and should have withdrawn earlier or should have asked for court-appointed counsel earlier. And now it's late. He ought to be required to stay on the case. And I see everybody's argument for that. I understand the frustration. I am sure that Judge Boyce is livid. I'm sure that he's livid because he has gone to, and his staff have gone to all of the trouble to get this case lined up for April with an out-of-county judge, an out-of-county courthouse. So the judge has done a great deal to try and get this case moving forward in April. All of those arrangements have already been made. And now he looks like a complete fool because he's got to go back to the court and say, well, Judge, well, Ada County, we're not going to go forward in April. And I understand that he's got to be just furious over it. I would be. I'd be livid if I realized that after all the work that I and my court staff had already done to bring this case to Ada County, we're being told, oh, so sad, we can't do it. I can't blame him for being furious. However, it's not about inconvenience. It's not about inconvenience or the cost that it might be to John Pryor. The only thing the judge can consider is whether or not Chad Daybell's right to a fair trial would be compromised by going forward, by forcing Pryor to go forward in April. So while I think there's a lot of people out there that are really frustrated who don't like John Pryor and who would love for the judge to say, Mr. Pryor, you need to stay on the case and you need to work for free. I get it. I get that there are people out there that find John Pryor abrasive, who find him to be kind of a little on the bombastic side. I get all of that. But the bottom line is that the judge can only think about Chad Daybell's right to a fair trial. He can't use any of his decisions as a way to punish John Pryor or to say to John Pryor, this is something you should have thought of sooner. Now, I do not disagree, and the judge may have other recourse to punish John Pryor for not getting off the case earlier and not notifying the court that Chad Daybell needed a court-appointed attorney. That is a different venue. It is possible that the court could file a complaint with the State Bar Association, could file an ethics complaint saying that John Pryor acted in a way that was unethical because he knew a year ago that his client was indigent. He knew a year ago that he was struggling to find somebody that was that had been capital qualified or could be capital qualified. He's known this for a very long time. Since well before the cases were severed, he's known this. But at a minimum, the cases were severed a year ago. And there's absolutely no excuse for John Pryor sitting on this information for a year. So the judge may very well have other recourse to penalize judge or hold John Pryor responsible. But in this motion, I don't think the judge has any alternative but to grant the continuance and allow the state to appoint Chad Daybell court-appointed attorney. I think there's something else going on. I think John Pryor, since the very beginning, has been trying to negotiate a non-death penalty alternative for Chad Daybell. Either the state has declined, which I would find doubtful, and I'll explain why in a minute, or Chad Daybell has just said, I don't think the deal is good enough. So if, as we think, that the prosecution has offered Chad Daybell a non-death penalty alternative, and here's why I think they have. Lori Vallow Daybell was found guilty after the death penalty was removed. There is an argument, although I don't think it's a good argument, at least on the appellate level, that Chad Daybell should face the same, that his possible outcome shouldn't be any more serious than Lori's. The reason I say it's not a great argument is because the court specifically removed the death penalty for Lori because of her, because as a penalty against the prosecution. It did not have anything to do with the with the strength of the state's case or the possibility that she might be found guilty. So, but I believe that the state doesn't really want to retry this case. They have said repeatedly this is a very expensive proposition for poor little old Fremont County. They have already spent well in excess of $3 million just to get to the point that they are now. That $3 million that $3 million amount was before Lori's trial. That didn't include any of the money expended on Lori's trial. So we know that it's probably more like $4.5 million that has been expended to get to this point. The prosecution doesn't want to expend another couple of $1 million that Fremont County doesn't have in order to prosecute Chad Daybell if they can get a reasonable plea. So I think they have said, we'll give you what Lori Vallow got. We'll give you 3 counts of life without parole. And I don't think Chad Daybell's been willing to take that. Here's the reason why. In Chad Daybell's mind, he is less culpable. Now, does that mean the law sees him that way? Absolutely not. Does that mean the prosecution sees him that way? Absolutely not. But Chad Daybell, in his little pea brain, has decided he is less culpable than Lori or Alex. And he is prepared to go to court and make the argument that he is less culpable. We know that because he's transmitted that over and over again in his pretrial motions. He said, I don't believe I'm as culpable. I don't believe I should be held responsible. I don't think you should be able to bring, I think you should be stuck with the argument that you made earlier that Lori Vallow is the mover shaker mastermind behind all of this and that I'm just an unwilling dupe. So he has made that argument repeatedly, and he's going to continue to make that argument when he goes to trial. I think that Chad Daybell, in his little naive mind, has decided he is less culpable and he will not make a deal for anything less than showing that he's less culpable. That would mean pleading guilty to less than first-degree murder so that he would be entitled to have his case. He would be entitled to a sentence that would allow him to be paroled at some point. Under the Idaho law, in order to do that, he would have to be found, he would have to plead guilty or be found guilty of a lesser included offense. So I think that they're at this loggerheads because I think that Chad Daybell and John Pryor have said, we'll plead him guilty, but it's got to be to something, to a lesser included offense so that he's eligible at some point for parole. I think Chad will not agree to life without parole. And that's where that's where the impasse has been. I don't know that getting a different attorney or a death penalty qualified attorney is going to change Chad Daybell's mind. So it seems to me at this point that the judge is going to have to grant his continuance, set the trial out perhaps until next fall at least, if not a year from now. And I don't think Judge Boyce has a choice. And it's unfortunate because it is maddening for Judge Boyce, for the public, for people who want this case to get to trial. It is absolutely devastating for the family who are still waiting for justice for JJ and Tylee. I saw an earlier statement from Kay and Larry that they're just saying it is what it is. There's nothing we can do to move the process forward any quicker, and we're resigned to however the case plays out. A lot of you have very kindly asked me what this does to my book, because we were so excited on Wednesday when I told everybody that I had pushed the send button on sending the manuscript out to my editor. Had Chad's case gone forward in April, I would have done a quick update having to do with the outcome of his trial, and the case would, the book would have gone to press in June. I have not discussed this with my editor yet because I really want to wait until his hearing on the 18th to find out whether or not the judge is going to grant Pryor's motion. I think that it is more likely than not. I would give this about 90% that I think the judge is going to grant the motion and allow the continuance. But I wanted to wait until I'd had the opportunity to talk with my editor armed with the facts. I suspect, because we have been waiting for this book for a long time, and I don't believe that the book heavily relies on what was going to come out of Chad's trial. I do believe that we can go forward without Chad's trial being resolved, just as we can go forward without Lori's Arizona cases being resolved. And it may very well be that when it comes out in paperback, we may be able to provide an update as well. But for now, I'm okay with it either way, and I'm going to wait to allow my publisher, my editor, to make that determination. So I'm not giving up. We're going to go forward as I'm going to go forward as if the book is going to come out. We're going to go to CRIMECON, launch the pre-sales, do all of those things that we've anticipated. If, however, my editor decides that we're better off waiting, then I'll go along with that as well. So I do want to take some questions. I did want to sort of keep this live since it was a surprise to about an hour, and we're at the half-hour mark. So I do want to take some questions. I know that Jennifer's in the chat and has been looking for questions. So if there are questions, please hop on and post some questions for us. Let me just pop this comment up while Jen's looking for it. These Idaho judges all want the fame, and now it seems as if Boyce rules in favor of this. Chad Daybell's court will not be happening, or he will get the death penalty off the table and keep his attorney. Well, Rose, I think that was the alternative that they were offering the court by saying, if you take the death penalty off the table, I can stay on and we can move forward. And I don't think that's an unrealistic thing to suggest, but I believe that I suspect that the prosecution has offered that. They just won't offer life without parole, so he won't plead. They won't offer to take life without parole off the table, so I don't think he'll plead. I don't really know if Idaho judges want fame. I think Idaho judges are stuck with the cases they're assigned to. It is interesting that Judge in the Koberger case has recently issued an order about how that case is going to be live streamed and how that is going to work. And he's allowed live stream, which we didn't see in the Daybell case or in Lori Vallow's case, but he's also said there won't be any live devices in the courtroom. So in Lori's case, the creators were allowed to live tweet from the courtroom. They were allowed to live comment, and that won't happen in the Kohberger case. There will be no live devices within the courtroom. There'll be no cell phones. They have to be turned off. And creators will only be allowed laptops for the purpose of note-taking. So it is a change from what we saw in the Daybell case. I don't know that judges are really looking to be famous. I think judges look at the judges who have been involved in some of these high-profile cases and think, man, this has not gone well for them. Look at the judge in Delphi. They're actually going to have a hearing again on the 18th at the Supreme Court in Indiana to determine whether that judge is going to be removed, as well as the prior attorneys going to be reinstated. There's some really fascinating information that's come out of Delphi that I would love to address, but we're going to do that on Wednesday because we're going to talk about what to anticipate the Supreme Court is going to do. So we're going to talk about that on Wednesday. I'm just pulling up my calendar to take a look at what's coming up. So we have the Supreme Court discussing we have the Supreme Court, let me get this right, is going to be hearing oral argument on Thursday the 18th about the Delphi case, whether or not to disqualify Judge Gall and whether or not to reinstate Richard Allen's prior attorneys. And there's some really interesting filings in that. If you have not, please follow Bob Motta at Defense Diaries on YouTube and and his podcast as well. He has a show that came out, I think, yesterday, talking about those new filings. We're going to talk about them, but it isn't going to be until Wednesday. So stay tuned for that. We're also going to talk about what to expect in Judge Boyce to do in this case as well, because I think that Judge Boyce has got some things to consider. But he is going to be considering whether or not to grant this motion. So I'm just looking through some of the questions. Let's see. I think this is a way to get Chad excused from the death penalty too. Pryor can't be trusted. He sure had plenty of time to watch Lori's trial every day in court. So, hi, Brenda. I hope you're doing well. I don't disagree. He did have time to watch a lot of Lori's trial. We did see him both in the courtroom and in the overflow room often. I wouldn't say he was there every day, but he was there often. So I do think that John Pryor is giving Judge Boyce two options: either set the trial over or get rid of the death penalty. I don't see this as untrustworthy on Pryor's part, but I do think that he is going to incur the wrath of the judge, because he should have and could have done this a long time ago. And I don't think, I think that he is, I think he has Judge Boyce kind of painted into a corner. I don't think that Judge Boyce is going to be happy about it. I do think that he seems to have the judge painted into a corner. Hi, Jacqueline. Seems like Chad's attorney agreed to take this on when the house was signed over to him. Perhaps the judge should decline the withdrawal, offering them standard public defender pay. I think John Pryor wishes that could happen. And John Pryor says in his motion that he would accept being appointed at standard public defender pay if but he can't do that unless the death penalty is off the table. I will point out that it is not unusual for someone who is facing large public defense or large attorney bills to sign over their right to their interest in real property in a home. It's not unusual to give the attorney a lien against your home or your real property. So I don't think that is unusual. He did not agree to take this on when the house was signed over. He agreed to take it on when he started representing Chad back in June of 2020. At that point, there was still money from Lori, from Tammy's life insurance. We don't know how much of that went to Mark Means before he withdrew to represent Lori. We don't know how much of that was left and was signed over to John Pryor. But death penalty cases are incredibly labor intensive, and it doesn't surprise me at all that John Pryor has gone through all of that money. We said that a long time ago. We talked about that a long time ago. John Pryor would said in his motion that he would agree to be appointed and take the case at public defender rates, which are nothing, by the way, if the death penalty comes off the table, because it's not an option because John Pryor's not death penalty qualified. Becoming death penalty qualified is a process, and it's not something that I don't think John Pryor could accomplish, could have accomplished since he took on the case. Silly Me says, I don't think Boyce is going to cave and remove the death penalty. I agree that I don't believe he's going to take the death penalty off. And I agree that means that the case is likely going to get continued. Pryor does not want to remove himself. It is a trick to get the judge to remove the death penalty. Well, I think that that John Pryor has put the judge in the position of either removing the death penalty or continuing the trial and appointing new counsel. I don't know that the judge is going to agree to take the death penalty off, and I do believe that John Pryor is going to be allowed to withdraw. So I do want to wrap this up within an hour or less, because our lovely mod, Jen, who is volunteered to jump in at the last minute, is headed out of town for the long weekend, and I don't want to throw a monkey wrench into that in any way. So this one says, hi, Jennifer. I bet Pryor thought Chad would plead out. I think that this has always been on Pryor's radar. It's on every lawyer's radar. You're always looking for a way to resolve the case without taking it to trial for a number of reasons. It's expensive. It's stressful on everybody involved. It's hard on all of the witnesses and the family members who don't get any certainty out of what's going on in their lives over what's going on in the criminal case. It absolutely, every lawyer is going to be looking for a plea. But as I say, I think they have reached an impasse because Chad is not, I think that the prosecution would, in a heartbeat, resolve the case for the same sentence Lori got. I think the reason we didn't see plea negotiations until after Lori's sentencing was because they were not willing to talk about plea until after that happened. But now that her sentencing has happened, we know what she got. I think the prosecution would happily give him the same thing that she got. However, I think in Chad Daybell's little pea brain, he has decided that he is less culpable than Lori Vallow, and therefore the death penalty should come off the table, and he should get some sort of deal that would allow him at least the hope of parole. I do not believe that the prosecution will go there. And I think that's the impasse. And I don't blame the prosecution. They have nothing to lose. They have no reason to enter into that sort of an agreement. They know they can get a conviction based on exactly what they presented in Lori Vallow's case. They don't have to put anything else on. They can go back to court, put exactly the same case on against Chad, and get the same result. So why in the world would they agree? Because they believe that they can put that case on, and they believe that they can put on an adequate case in the sentencing phase, that they'll get the death penalty. That's what's hanging over Chad Daybell's head. I think it is utterly foolish on Chad's part, but we do not know Chad's mindset. Does he still believe God is going to deliver him from the death penalty? Does he still believe that he is a prophet? Does he still believe the end of the world is coming? And like the Apostle Paul, the earthquake's going to happen, and the walls of the jail are going to fall in, and he's going to be released? I don't know. We don't know whether he believes any of that anymore. We don't have any way to judge that. Now, everything that we have seen is that Lori Vallow still 100% believes all of that. Everything we have seen is that Lori Vallow is not remorseful. She believes completely that she is a goddess, that the end of the world is coming, and that God is going to vindicate her. That's what we know. But we don't know whether Chad's still there or not. There's no way for us to know because nobody's talking about it. So all we can do is just do our best with what we know to read between the lines and try and surmise, try and do some educated speculation about what's going to happen. So I think at this point that we are just, I think at this point we are looking at there is going to be a delay. I think Judge Boyce is going to grant the John Pryor's motion to allow him to withdraw, and is going to push the trial out maybe as much as a year to allow new counsel to get up to speed. And it sucks for everybody. It sucks for the victims and the families who have been waiting so long, because, you know, there's an old adage, justice delayed is justice denied. And that is as true for the families and the victims as it is for the defense. So every delay really denies justice for the families. And I know that it is hard and it is frustrating for everybody involved. I know that it is really frustrating and miserable for everybody involved. So, snow, come to Utah. We have all kinds of storms lately. You know, we have had our share. Now, I guarantee you that we have not had anything like what y'all have had in Utah and on the other side of the Rockies. I know that you guys have all had terrible dumps of snow. But my hometown in Bend has been getting just dumped on with snow. They're having snowpocalypse. So we are not having snowpocalypse. We've had probably over the last week or so, maybe 4 or 5 inches of snow, enough that my lovely neighbor, thank you, Carl, got his snow blower out and came down and went up and down the street and ran the snowblower on all the sidewalks and ran the snowblower on all of the driveways, and said he doesn't get he's from Chicago, said he doesn't get an opportunity to get his snowblower out that often, and he enjoyed doing it. So my husband, Carl, used to love getting up in the morning and running the snowblower. It was sort of his morning commune with nature, if you will. But so it was very sweet of him to do that. We have not had any appreciable snow for the last 24 hours. Thank you. Because it's hard for people to get around. My husband actually ventured out today and took the dogs to the dog park because they love to play in the snow. And when there are other dogs around, they love it even more. So I will be looking forward to snow-caked paws, since I have Labradoodles and they come in just looking like big snowballs when they come home, but they love it. I do keep the little Chihuahua guy home because he's not equipped for it. So, Jennifer M., it absolutely is a way to get the death penalty lawyers at the state cost. It absolutely is. There's no could about it. The issue is that people who are death penalty qualified generally are lawyers who routinely take public defense cases. And as John Pryor's motion pointed out in his motion, or in the declaration, which is still I can't get to download off the state's site, so I apologize for that. We'll try and get it up in our show notes as soon as it is available. But it absolutely is a way. What Pryor pointed out is there is a real shortage of death penalty qualified attorneys in the state of Idaho. You might remember at one point we posted that information, and there is somewhere, the list changes month to month, but there's somewhere between 25 and 29. Not all of them are qualified to be lead counsel on death penalty cases, because that takes additional supervision and additional certification. So there are a handful of lawyers, because the process works that you have to have sat on so many complex felonies as the main or lead counsel. And then after that, you have to have been the second chair on some death penalty cases in order to become lead counsel. So there's a lot of people who've met that first step, but have yet to be able to sit second chair on a death penalty case and get fully qualified to be lead counsel. So there's maybe 10, maybe 15 statewide that are qualified to be lead counsel. Two of them are Jim Archibald and John Thomas, who were already on Lori Vallow's case and are conflicted out. So it is going to be very difficult for them to find people who are willing to come on and take on the case. Also, going to be difficult to find people who are going to be willing to take on the case if the judge sets the trial out on a short fuse. That's the other piece. If the judge doesn't set his case out for a year, you're going to have fewer death penalty qualified attorneys who are going to be willing to take the case, because this isn't their only case. They may very well be prepping for trial for death penalty cases in 2024, and they may not have the bandwidth. They may not be available and have the time to take a death penalty case until next year. So I know that there's a lot of people that want the death penalty to stay on the table. I do believe that it will, because I don't believe that Chad Daybell will enter into an agreement to take what Lori Daybell got, because I just don't think he will. If he had been willing to accept a sentence that's what she got, he would have already entered a plea. we wouldn't be here. And I have absolutely I would be stunned. I am 99% sure the prosecution has offered them that deal. But Chad Daybell has decided he's not as culpable as Lori was, and so he shouldn't get that sentence. He should get some sort of sentence that allows him parole after some period of time. That's my speculation. That's my educated guess, is that John Pryor has not been able to get his client to agree to what he thinks is a reasonable deal. And so here we are. Let's take a look at what Leah's got. Question: can the state not pay Pryor like they didn't pay Means and acquire him a death penalty certified county counsel? Yes, absolutely. And that's actually what John Pryor is asking them to do. John Pryor has said, so that was a tricky situation with Mark Means, because they didn't pay Mark Means as a state lawyer, as far as I know. He was never appointed as and receiving public defense funds. He was disqualified fairly quickly after Jim Archibald was appointed. The other thing that's a little strange about that is that at the time Archibald was appointed, the death penalty had not been requested, and Lori had not been charged, because that was during the time when her charges were told because she was incompetent. So let me see if I can parse that out. When Lori was declared indigent and the judge appointed Jim Archibald and left Mark Means on the case, it was not a death penalty case because Lori had not been indicted on the murders. She was still being held on the earlier charges. Though that case was told because she was incompetent and was receiving treatment. So when Jim Archibald was appointed, there weren't murder charges on the table yet. The judge clearly knew they were coming, but shortly after Jim Archibald was appointed, shortly after those charges were filed against Lori, Means was removed because of his conflict. So it's slightly different situation, because the judge could not leave John Pryor on and appoint a lead counsel over the top of him, because he's not even qualified at this point to second chair. So now, we talked at length about the fact that John Pryor could have gone to the state and tried to get qualified to second chair earlier, but he hasn't done that. So, and to be honest, I think John Pryor is over it. There comes a point when you realize that you are not going to be effective with this particular client. I think that he has reached that point because he has routinely and regularly told Chad Daybell, take the deal for life in prison without parole. And Chad Daybell has not been willing to do that. So I think there's an impasse. And I think that although John Pryor has said this has to do with the fact that Chad doesn't have any more money, can't afford to continue, and John Pryor can't continue because he's not death penalty certified by the state, I think there's an element of that as well. I think he could have said, my client and I have irreconcilable differences and I can't be effective representing him anymore. He didn't say that because that may be a bridge too far for him, but he may feel like that means that they I think he feels that might be prejudicial to his client. Let me get back. Hello, Sarah Adams. We haven't talked to you in a little while. It's nice to see you in the live chat. Leah says, I mean, like they paid Means. I'm not sure that the state ever paid means. That's the point I'm not clear on. When I did the FOIA request asking the court or asking the state public defense, I FOIA'd, I sent a Freedom of Information Act request for the records from the public defense services. And I was told at that point that the public services department had not expended anything on behalf of Lori. So I don't believe that Mark Means was ever paid out of state funds. I think it's possible that some of his expenses, like experts or those sorts of things, may have been covered. But I don't believe he was ever compensated for his representation of Lori. I think that it started out being that he was paid. When she was declared indigent, he stayed on pro bono. And I don't think that he was all that unhappy about being booted from the case when he was, just because he was continuing on pro bono. So I don't have any evidence at this point that the state ever paid Mark Means for representing Lori. It could have happened, but like I say, I wasn't able to uncover it. Linda asks how Michelle is doing. I hope she's doing really well. I haven't heard from her in a little while, but we really need to keep her in our prayers. Thanks. Sorry, I'm trying to pull up comments too. Anyone else hear Hidden True Crimes opinion? I want to know if Lori agrees. You know, Linda, I haven't listened to it. If you want to clue me into what their opinion was, I'd be happy to address it. Leah Simmons says, oh, sorry, I did a voice text and it didn't come through right. Why didn't he do this earlier? I think that's a great question, and I join you in wanting to know. I join you in questioning why he didn't do this sooner. And I'm sure that Judge Boyce is going to ask that same question. You knew that Chad was indigent a year ago. Why didn't you do this sooner? You know, I think John is going to say, well, I was trying to get this death penalty qualified person on board. I was trying to get this person death penalty qualified. The states, it's all the state's fault because they were dragging their feet, and this person could have come on and I could have second chaired for him. And I don't know. I mean, I think that's going to be the excuse, but who knows? Let me just look at a couple of more. Hi, Julie Reichart. Okay. John Pryor knew a long time ago that he wouldn't be able to finish the case. Good play, John. Get all the money while it's there, then delay the trial. Well, I can't disagree. Mandy, you're a paralegal. I am sure that you have seen this before. I have seen lawyers take cases, run through the money, and then say, sorry, but we're done. You know, but I do want to say that there are instances where a lawyer takes a case and the case becomes much bigger than the lawyer anticipated, and they run through the money. I mean, there's no question that John Pryor understood that that this was going to be an expensive case. So it's hard to say how much of the money that would have been that would have come from the home had been expended for experts, because we know that John Pryor hired experts. We know that he hired a DNA expert. That couldn't have been cheap. So we know that some of that money may have gone for experts. I understand people's skepticism with this because I've seen it myself in practice. Lawyers who say to a person, it happens in family law all the time. People will say, give me X number of dollars and I'll represent you in your divorce. And then when the retainer's gone, they say, gosh, I need more money. When the client says, well, I don't have any more money, they say, oh, sorry, got to withdraw because you're not going to be able to pay me. So it is a difficult kind of situation. I'm sinking down in my chair here because part of it is you can't anticipate it. Part of it is when the money's gone, the lawyer doesn't have to work. So I think Pryor is using this to get the death penalty dropped, but Chad waived speedy trial, so no pressure on the court to get this thing to trial. Well, I agree, although I will say that there are issues, speedy trial issues, that arise even for defendants who have waived their speedy trial right, because at some point it becomes a violation of a person's right to a speedy trial, even if they have filed a waiver. So there are court cases out there that say that if your client has been locked up for 2, 3, 4 years waiting for a trial and hasn't gotten to trial, there's a speedy trial issue. Now, there's also case law that says that if the defendant is responsible for the delay, that you can't raise that speedy trial issue. So if the defendant is, and in this case, if we look at the declaration that was filed, in fact, both the motion and the declaration say that Chad Daybell understands and agrees to this request. I think that takes that speedy trial appellate issue off the table, because the state's going to say, look, we didn't ask for this, we were ready to go. Chad Daybell's the one who needed a new lawyer, and Chad Daybell's the one that asked for the delay, and Chad Daybell's the one who didn't ask until 4 months before trial. He's the one who's responsible for that, not us. So I don't believe Judge Boyce is going to drop the death penalty. I do believe that he's going to allow Chad to have extra time, and I do believe that the case is going to be set out probably a year. If I had to estimate, that's what I would say. Let me see if we find the comment. Somebody asked me about Hidden's opinion, and I said if you, I haven't listened to it, but if you have put it in the comments, I'll remark. Let's see here. In my opinion, hi, Sheremy. In my opinion, was so irresponsible and unethical of John Pryor not to withdraw from the case much earlier if he was not planning to see it through for personal glory. Well, and I agree, and I see that you corrected it to unethical. I can't disagree. I think that John Pryor should have known quite a long time ago that he needed to withdraw from the case. I don't know about the personal glory point. I think if you ask the people who were involved in Jodi Arias's case, they would categorically tell you that there was no personal glory in representing a defendant in a high, an unsympathetic defendant in a high visibility case. I think if you ask Kurt Nurmi, he would say it wasn't worth it. He got disbarred. So I'm not really sure Leah says, I'm actually bummed. I wanted to see John Pryor in action because he's quite a character. Well, I agree. He does have an interesting courtroom persona, and it would have certainly been more stimulating and interesting than Lori Vallow's counsel. Let me see. Can Judge Boyce prevent him from withdrawing or force him to stay on to help with the new attorneys? So Judge Boyce can prevent him from withdrawing, but I don't think Judge Boyce can prevent him from withdrawing and say the case has to go to trial in April. I think that it's going to be one or the other. He could say, yes, you can't withdraw because it would prejudice your client. But I don't think that he can say you can't withdraw and you have to try the case in April. I think that would be too much, and I think that would get overturned on appeal. He will be expected both ethically and legally to help with the transition to new counsel, including providing them with all of the discovery and probably with his work product as well, with his research and all those things. I think it's a power play and a strategic move on the defense's part. I don't disagree. I think that John Pryor has Judge Boyce in a tough spot. John Pryor isn't death penalty qualified. I know they have to have two. So my understanding of the Idaho rules is that John Pryor could be added to the death penalty qualification list as a second chair because he's never sat on a death penalty case before. So my understanding is he could. Whether he would or not, I don't know. Hard to get good help even in Idaho. You're not wrong. Here is the issue. The issue is that public defenders are not paid enough. What we know is that a death penalty case will take over a lawyer's practice for a good year. That means that they don't have the time, the energy, the resources to also take other cases, which means that their sole source of income for that year has to be that death penalty case, and they pay crappy. So it's very difficult to find. That's why it's difficult to find death penalty qualified attorneys who will take a case at the piddling state rate. In general, public defenders make somewhere between 1/2 and 1/3 of what the district attorneys on the other side make. That's just the reality. In a lot of places, my home state of Oregon, they are not state employees. They don't get state retirement. They don't get the access to state health care. They have to do it all on their own. They are considered 1099 private contractors with the state. And it's incredibly frustrating. Now, there are other states that have state agencies that are public defenders. But even within those state agencies, they often have to send cases out to conflict lawyers, and they're not paid worth a damn either. And in a lot of states, public defenders are still paid less. Even if they are state employees, they're paid less than the prosecutors and the attorneys general. So there is a reason why it is very difficult to get public defenders these days. The consortium that I worked for in Oregon, it has been virtually impossible to attract new lawyers. They can't attract new lawyers directly out of law school because they can't devote the time to training them. And there is a learning curve and a training process that has to happen. And those individual lawyers who are also practitioners who take public defense cases as contractors don't have, if they train a new lawyer, they're doing it for free because the state doesn't pay them to train new lawyers. So they end up being stuck, not being able to train new lawyers to come into the practice. And new lawyers just look around and realize that they can make 3 times as much if they go to work for the state as prosecutors, or they can make 3 times as much if they go to work in private firms. So it's a no-win situation getting people to do the righteous work of public defense. And it's frustrating. We're going to take a couple of more questions and wrap it up so we can let Jen get on her way to her vacation weekend. Michelle, Mom, Granny, Alma, Gigi, I think that you were entitled to a private attorney who isn't death penalty qualified, but I think on conviction, it would be considered ineffective counsel. Hopefully, Lori will clarify. Good question. What the rules say is that if you retain your own attorney that you are paying for, you can have whoever you want because it's up to you to decide whether that person is qualified or not. If, however, the state is using state taxpayer money, they have the right to make sure that the people that they appoint meet minimum qualifications. So in the state of Idaho, they put rules in place that say lawyers who do death penalty cases have to meet these minimum qualifications. And that's what we mean when we say death penalty certified. Means the state has said, yes, I believe that you've met all those minimum qualifications. However, if a person hires their own retained lawyer and they hire someone who does not meet the state imposed, they hire privately someone who does not meet those state death penalty qualifications, it's not considered ineffective counsel because it would be like saying, I hired the wrong lawyer and now I'm going to go complain to the and get a new trial because I had ineffective counsel. So the argument works both ways. The Supreme Court is not going to give you a new trial based on ineffective counsel if, in fact, you are the person who vetted your lawyer and hired them and you hired ineffective counsel. Hopefully that makes sense. So, in the meantime, I will go back and take a look at comments and see if I can pull up any other questions, but we do have one here. Why was the court not on top of the fact that Pryor had not been death penalty certified or brought a death penalty qualified attorney? Well, Susie, for the reason I just described, if Pryor is retained, which he was, then it is up to Chad Daybell to decide whether or not he is appropriately qualified to represent him. And it's not the state or the judge's job to decide that. So the judge knew that this was, I'm sure knew that this was an issue, a potential issue, if Chad requested a court-appointed lawyer. But up until the time Chad made that request, it wasn't an issue. So good question, guys. And thanks for the super chat. So I am going to go back through the chat. I will look more at everybody's questions because I see a long list of questions that I haven't gotten a chance to answer yet. But we do want to let Jen get on to her long weekend. And so I want to thank everybody for joining us. We have 550 people in the live chat. Thanks for joining us. It's nice to be able to do this at a time a little bit different than Wednesday nights and to welcome folks that we don't always get during the live. So welcome to you all. I appreciate you joining me. I'm glad we got the chance to catch up on this juicy little tidbit. And I will see you all next Wednesday, where we will I'll do my best to address any questions that I see in the chat that I've missed, and we'll get back together on Wednesday. So thanks again, you all, for joining me. And thanks, Jen, for jumping in at the last minute. And Michelle, be well. Take care.